Good afternoon and welcome to my lecture on lawyers' ethics for Philosophy 3200. Now there's a particular issue in legal ethics that I want to talk about here, but to set this up, here's the problem. So lawyers often engage in what I call unjust advocacy. That is, they advocate for legal outcome that they, the lawyer, know to be unjust. Now typically, it's not considered morally acceptable to intentionally promote unjust outcomes. But it is considered acceptable for a lawyer to do that in the course of his job. This unjust advocacy is in fact considered to be required. It's considered to be ethically required or required by your job if you're a lawyer and the unjust outcome is in the interest of your client. Now, I think there's a general principle that I call the duty of justice, which is just that it's morally wrong, at least prima facie, to cause or allow injustice knowingly. So the question is, why would it be okay if you're a lawyer to intentionally promote unjust outcomes when it's not okay for anyone else to do that? So the first general argument against devil's advocacy is very straightforward. First premise, it's prima facie wrong to cause or allow injustice. This is generally accepted in the rest of life. And second, there are no factors that cancel or outweigh this in the case of a lawyer serving the interests of a client. Conclusion, therefore, it's wrong for a lawyer to engage in unjust advocacy. Now let me discuss the first premise more. Why do I think that it's wrong to cause or allow injustice? So consider this hypothetical example. So let's say that Joe confesses to his friend Sally his deepest secret, that he, Joe, is a serial murderer. Now Joe asks Sally for help, for helpful advice on how he can elude the police. Now of course Sally is horrified and she tries to convince Joe that he should stop murdering people. But Joe is completely non-committal on this, so he won't promise that he won't do it again, although he's not saying that he will do it again. But he just wants Sally to help him dispose of the body from his last murder and evade the police. So imagine that Sally says, well, this is really bad what Joe has been doing, but Joe is a good friend. I've got to help my friend. And so he gives, not only does she keep his secret, but she gives him helpful advice about how to avoid being caught by the police. What do we think about Sally's behavior in this circumstance? Now, I take it everybody knows the answer, that this is horribly wrong. This isn't a difficult or controversial case. It's obviously wrong. Okay, now that illustrates the principle that just in general, it's wrong to cause or allow injustice. And the kind of injustice that Sally would be causing or allowing in this circumstance is just like the kind of injustice that lawyers will typically attempt to cause or allow by attempting to get their clients that they may know to be guilty, acquitted. Right? So the lawyer will keep the client's secrets and help the client to escape punishment. Okay, here's the second premise that I had. There are no factors that cancel or outweigh the prima facie duty of justice in the case of a lawyer serving a client. Now this obviously would be the controversial premise in the argument, so this is what we need to discuss in detail. What are the reasons that people give why it would be okay for a lawyer to advocate for an unjust outcome even though it's not okay for other people? So here's the first thing. Occasionally, a lawyer will say, well, you can't really know that your client is guilty. You can't be sure because, for example, even if your client confesses to you, it's possible that he's lying. Maybe the client is crazy and that's why he said that he did the thing that he maybe didn't do. Or, maybe your client is just trying to protect somebody else, so you can't be 100% certain that anybody is guilty of anything. Now, in response, this is really not a plausible objection because, typically pursuing a goal does not require absolute certainty. It only requires having a reasonable, justified belief about what is more likely to promote or frustrate the goal. So, for example, if you're investing in the stock market, you're not certain about whether you're going to make a profit or not. But you just need to have some reasonable beliefs about what is more likely to give you a profit. So in order to be able to engage in that purpose-governed activity. And one can have reasonably justified beliefs about whether a client is guilty or not. Note, by the way, that if you are going to require absolute certainty, well, you can't be absolutely sure of what serves your client's interests either. So if the argument is that a lawyer shouldn't try to promote justice because he can't be absolutely certain of what justice requires, then we'd also have to conclude that the lawyer shouldn't try to promote his client's interests because he can't be absolutely certain of what promotes the client's interests either. So here's a second argument that you find in the law review literature on this. The lawyer is like a friend to the client. And I take it that the idea behind this is a certain kind of partiality towards one's friends is justified. So you can be kind of biased in favor of your friends because of this special relationship that you have with them. So like, if your friend is double parked, you shouldn't go and hail the parking cop in order to get your friend a parking ticket, right? Then you're being a bad friend. Right, and so the idea might be that the lawyer is allowed to have this kind of special relationship where they're partial to their client. Consider the similar fact that if your spouse is on trial, you don't have to testify against them. Right, you're legally and morally excused from testifying against your spouse, even if you have knowledge of the crimes that they might have committed. Okay, so can the lawyer have this kind of special entitlement to be partial to their client? Well, there's something very strange about the idea of an instant friend that you acquire by paying them a retainer. Now, this doesn't really seem like a legitimate example of, the entitlement of partiality. Consider the case where, let's say, somebody commits a crime, and then, let's say, they marry one of the witnesses to the crime specifically for the purpose of preventing that witness from testifying against them. So that would not be legitimate. If you have a pre-existing relationship, then you can claim an entitlement to be partial to that person. But it doesn't really make sense that you can acquire this entitlement to partiality after the fact, specifically because the person who committed the crime is hiring you to be partial to them. Note anyway that even if you believe in this, there are limits to the requirements of friendship. There are limits to the partiality that you're ethically entitled to show towards your friends. And that was shown by the murderer's friend example on a previous slide. In fact, that's the reason why I described that example the way that I did, that Sally was a friend of Joe. Because you're supposed to see in that example that, if your friend has committed some heinous crime, and there's a pretty good chance that they're going to commit more crimes in the future, the duties of friendship do not extend to protecting them against being punished for horrible crimes. Right? They do not excuse you in allowing innocent other people to suffer from the crimes that your friend has committed. Okay, here's another thing that is very frequently said. It's said that, look, advocating for your client's interests, that's just the job of a lawyer. If you're not prepared to do that, then you have no business taking that job. It's not the job of the lawyer to assess what justice requires or doesn't require. It's just their job to put forward the best argument for their client's side of things that they can come up with, and then somebody else's job to assess what justice requires. Now, in response, immoral actions in general do not become moral merely by the introduction of employment opportunities for the people who do them. So it may be very well true that advocating for unjust outcomes that are in the interests of your client is the job of a lawyer. That doesn't make it not immoral. So consider the example of an assassin who works for the mafia. And you imagine, the assassin is going to go kill someone, and you tell him that that's morally wrong, and then the assassin says, well, it's just my job. I'm an assassin. The job of an assassin is to murder the people that the boss wants to be murdered. It's not my job to decide whether the person really deserves to be killed or not. And so as a factual matter, as a descriptive matter of fact, that's true. It's true that his job is just to murder people and that it's not his job to assess whether the murder is justified or unjustified. But the fact that that's his job doesn't mean that it's not horribly immoral. And so similarly, the fact that unjust advocacy is the lawyer's job doesn't mean that it's not immoral. Okay, here's another thing that's sometimes said. Sometimes said that, look, you should just have faith in the system. And the system that we have, maybe is the most reliable system that humanity has devised, and it just works best if everybody does their jobs. If everybody does their jobs, then you should just trust that the system as a whole will get the correct result, even if your individual advocacy is for the incorrect result. Now, in response, this just seems to me to be an unjustified faith. Maybe the system is usually reliable, but you can definitely have a case in which you have good reason to think that the system is not going to be reliable. You can definitely have good reason to think that there will be a miscarriage of justice if you advocate for it. And one of the reasons for this is there can be asymmetric skills. That is, you can have two lawyers in the case, so we have an adversarial system, which means that there are advocates on two different sides in a particular case, but one of the advocates could just be more skillful than the other one. They could be more intelligent, more knowledgeable, more experienced. Their side might have more money, so they could hire more people and spend more time looking for arguments and looking for ways to frustrate the other side and so on. Another thing is there could be asymmetric information. So you as the lawyer in a case might have information that the other side doesn't have. Okay, now if you're a prosecuting attorney, you're actually supposed to share all of the information that you have. Unfortunately, they frequently don't do that, but they are legally supposed to share all of their information, particularly if they have exculpatory information about a defendant. But if you're a defense attorney, you're not required, and you generally will not share information. So you might have information that shows that your side is wrong, and shows what justice actually requires that isn't in the interest of your client, and then you might just conceal that information. So then you'd have good reason to think that the system is not going to get the correct outcome. Another reason that there might be a miscarriage of justice is it's possible to confuse jurors. So you might have a clever attorney who can just manipulate people's emotions or just get them confused about the factual evidence. And so there can easily be a miscarriage of justice. It's really not highly improbable or bizarre that that would happen. Also, by the way, there are ways of kind of manipulating the legal rules in order to achieve outcomes that are kind of in your side's interests. But many of these methods of legal manipulation really don't have anything to do with pursuing justice. So, for example, you might try to get evidence suppressed at a trial. You might try to make some kind of technical argument for why this evidence was not collected in the right way and therefore it should be suppressed. And then you can have reason to think that that's going to cause the incorrect outcome to occur in the trial. Or here's another kind of thing you can do, abuse of the discovery process. So the discovery process is the process by which two sides in a trial get information from the other side. Right, so if you're in a lawsuit, you're allowed to send questions to the other side that they're supposed to answer truthfully. Okay, so one thing that you can do is just totally abuse this process. Like if you have a bunch of money, you can hire your lawyers and you can have them just send tons of questions to the other side that their lawyers have to read through and spend time collecting information about, and then just waste their time. And the reason you would do this is it costs the other side money. So, just abuse the process so that the other side has to rack up legal fees in order to respond to all of your frivolous requests, and then that's a way of pressuring them into settling. Okay, so if you're doing things like this, and these are things that are widely practiced, right? I'm not making these things up. These are not unusual cases. These are widely practiced and are considered to be okay legal tactics. These obviously have nothing to do with pursuing justice, and there's really no reason to think that if everybody does this sort of thing, everybody uses these legal manipulation techniques, that that's the best way of achieving justice. Okay, now another thing that's commonly said is, well, the best consequences overall will occur if people in general follow this rule of just carrying out their role in the system. So, if lawyers in general just try to serve their clients' interests, then overall the system will have the best consequences. Now, the first thing to say about this is, rule consequentialism is highly controversial in ethics, right? There are a lot of objections to this view, so you can't just assume that that is the correct moral view in general. But I'm not going to talk about that in detail because that is a bigger topic, right? It's like a big topic of debate in moral philosophy. But the other thing that I want to say is, there just is no reason to believe this factual claim. It's very frequently said, but people never give you a reason for thinking that the best consequences will occur if we have a general rule that lawyers just try to serve their clients' interests. Why would that produce better consequences than a general rule whereby people try to produce the right outcome? Like, generally speaking, you would think that justice and correct outcomes are more likely to occur if the people involved in the system care about them and try to make them occur, rather than if people just ignore them. Okay, here's another argument that you might make. You might think, yeah, but defendants have a right to a fair trial. And you might worry that in order to have a fair trial, you have to have a zealous advocate. You have to have a lawyer who is going to advocate for your interests, regardless of what justice may require. And so if you have lawyers who are not willing to defend guilty clients, then that means that people who appear to be guilty are not going to get a fair trial. Now, in reply, note that there's no one in particular who could be accused of violating a defendant's rights if a lawyer doesn't want to take a case because he thinks that the defendant is obviously guilty. Right? So a particular defendant does not have the right to be defended by a specific lawyer. And my issue here is what a particular lawyer ought to do as an individual, right? My question here is not about how the system as a whole should be designed, it's about the ethics for the individual lawyer. So if an individual lawyer says that he doesn't want a case, that's not a violation of anybody's rights because that defendant didn't have a right to have that specific lawyer. And it's highly unlikely that there will be no lawyer in the society who's willing to take the case, so he's not going to have his rights to a trial denied. Even if somehow, bizarrely, every single lawyer in the country thinks this guy is obviously guilty and is unwilling to defend him. Still, you couldn't really accuse the state of having violated that person's rights because the state didn't prevent the person from hiring a lawyer. So, legally speaking, the state wouldn't have violated the person's rights. The second point to make is, it doesn't really seem like it's unfair to not have someone help you make deceptive arguments for unjust outcomes. I mean, look, if every defense attorney thinks that you're obviously guilty and doesn't want to make the argument that you want to make, then, you're almost certainly guilty. That's a lot more certain than it is that you're guilty if you got convicted by a jury in our current system. Remember that the right to a fair trial is presumably based upon a right against wrongful convictions. The purpose of a trial is just to prevent wrongful convictions and to secure correct convictions. It's to find out the truth so that justice can be done. And so therefore, when we decide what counts as getting a fair trial, like what kinds of conditions the defendant is entitled to insist on, we should think about the conditions that are required to have a reliable method for finding out the truth so that justice can be done. Right, so we should say, well, yeah, the defendant has a right to insist upon having a reliable procedure used. But that does not mean that the defendant has a right just to have conditions that are favorable to himself. And so in particular, there's no right to have somebody make deceptive arguments or try to manipulate the jury or try to secure biased jurors during the jury selection process, which is another technique that's used, right? There's no right to those things. Those things can't be considered part of the fair process because there's no reason in general for thinking that they make the trial more reliable, and you only have the right to insist on a reliable procedure. Now, in particular, having a process in which some intelligent, well-educated expert deliberately tries to mislead the tribunal, there's no reason why you would have a right to that. That is not a way of making the whole procedure more reliable, right? So it doesn't seem that the right to a fair trial should include that. Okay, now that was all about the first major argument for why advocating for unjust outcomes is wrong. This is the second major argument. It's the argument from the wrongness of deception. So first premise is it's wrong for a lawyer to lie, suborn perjury, or introduce falsified evidence. Okay, suborning perjury is basically intentionally getting people to lie on the stand. So if you know that a particular witness is going to lie, you're supposed to either not put them on the stand or not ask them the questions that you know they're going to lie about. In this first premise, this is uncontroversial. This is already accepted in conventional legal ethics, right? Although the lawyers are supposed to advocate for their client's interests, they are not supposed to introduce falsified evidence. They're not supposed to lie about factual matters. They're not supposed to suborn perjury, and you can get in trouble for all of those things. And this is accepted on all hands by lawyers, prosecutors, judges, and so on. Now, my second premise is there is no morally significant difference between those things that are considered unethical and typical cases of unjust advocacy. And so therefore, it's wrong for a lawyer to engage in unjust advocacy. Obviously, the second premise is the one that's controversial. Why do I think there's no significant difference between the things that are considered immoral and typical cases of unjust advocacy? Well, first, why are those other things considered immoral? Why is it considered wrong and legally impermissible for the lawyer to lie during a trial or suborn perjury or introduce fake evidence, right? Well, the reason is just that those actions, they undermine the purpose of a trial. They deceive the tribunal and thereby undermine the function of securing justice. They undermine the ability to determine the truth, which is necessary to secure justice. And there's no reason why allowing that sort of thing would make our process reliable. And so that's why those things are not considered allowed. But notice that unjust advocacy is also deceiving the tribunal and thereby undermining its function of determining the truth so that justice can be done. Indeed, it does so more clearly and more directly. So if it's wrong to lie about a factual matter because lying about the factual matter will deceive the tribunal about the correct outcome of the case, then it should be wrong in general to directly try to mislead the tribunal about the correct outcome of the case. And that's what unjust advocacy is. If a lawyer is advocating for what he knows to be an unjust outcome, then he's trying to deceive the tribunal about the one thing that matters most, which is what's the correct resolution of the case. Note in general that we don't think that indirect deception is morally superior to direct lying, right? So like sometimes children think this, that if you deceive somebody without literally lying, that it's okay, but normal mature adults don't think this. So let me give an example. Let's say that I'm asked to write a letter for the tenure case of a professor at some university, and this letter is going to be used by the committee to decide whether this person gets tenure. Suppose that I write in my letter, Professor X should be granted tenure, and his drinking problem is not a reason for denying him tenure because he comes to class sober at least 80% of the time. Now suppose that after writing that, suppose that I know that Professor X in fact does not have a drinking problem and that he's always sober in class. Well, it would obviously be wrong for me to write that letter, and it's obviously not significantly better because I didn't literally directly say that the guy was a drunk. I just implied it, right? Just, because it's literally factually true that his drinking problem isn't a reason for denying him tenure because he doesn't have a drinking problem, right? But I'm obviously trying to get the reader to draw the incorrect inference. Okay, so what lawyers are doing, they're not allowed to literally lie, but they are allowed to intentionally mislead. So basically what the lawyers what's considered okay for them to do is like the thing that I'm doing in the letter, right? Where they say something that they know is going to cause the audience to draw a false inference, but they didn't literally say the false thing. Okay, that is not significantly better. Okay, now I want to stress that what I'm saying here is not that it's always wrong to defend an obviously guilty client. I'm not saying that because there are some reasons why it would be justified to defend somebody who's obviously guilty. First of all, even people who are guilty of a crime still have rights, and they might need a lawyer to help prevent their rights from being violated. For example, to prevent them from being excessively punished, right? Even if you did something wrong, it could still be that the prosecutor wants to punish you unjustly, that is, in a way that's excessive. Also, some law violations are not morally wrong and don't deserve to be punished. So it could be completely ethical to try to get a person acquitted of something that they did because the thing that they did might actually not be wrong and the law itself might instead be wrong. Also, you might just think that the punishment that's assigned for a particular crime is so excessive that it's better, that it's more just for the person to completely go free than for them to get that excessive punishment. So if that's the case, then it's completely ethical to try to get that person acquitted. Also note, by the way, that in general, we think that punishing an innocent person is worse than merely failing to punish a guilty person. And that explains why it could be ethically acceptable to attempt to get someone acquitted, even if they're probably guilty, as long as there's a reasonable chance that they might be innocent. It could still be ethical because punishing the innocent is so much worse than failing to punish the guilty. All of this, I note, applies to civil as well as criminal cases. Now, the most prominent cases of unjust advocacy are trying to get a guilty person acquitted, but you can also have unjust advocacy in a civil case where you try to get an excessive award for the plaintiff, or you try to defend somebody from having to pay just compensation in a lawsuit. And also note that this applies to prosecutors as well as defense attorneys. So unjust punishment, again, is worse than merely the absence of just punishment. And so therefore, unjust advocacy by prosecutors is an even more serious matter than unjust advocacy by defense attorneys. And what I mean by this unjust advocacy by prosecutors is, the prosecutor trying to get somebody convicted either of something that they didn't do or trying to get them convicted under an unjust law. So it could be something that they did, but something that doesn't morally deserve punishment, or a prosecutor trying to get excessive punishments. So trying to get this person sent to jail for 20 years for stealing a sandwich, which, by the way, that is an actual case. There's a case where somebody got an enormous sentence like that for stealing a sandwich from a Whole Foods market in Austin, Texas. Okay, and this sort of thing is actually very common. Prosecutors in our current system typically view their job as being to win and not necessarily to serve justice. Now, according to the official doctrine, the prosecutor's job is to serve justice. So prosecutors in accepted legal theory are not supposed to prosecute people who are not guilty, and they're not supposed to just try to cause as much harm as possible. They're supposed to try to achieve justice, but that's not typically the way they think of themselves. Typically, because it's an adversarial system, the prosecutor thinks that it's them against the defense attorney, and they're trying to rack up wins. They're trying to have a high conviction rate, and they try to cause more harm to the defendant because that's how they see winning against the defense attorney. Now you might wonder, well, why is this devil's advocacy view so popular, given that it seems to be morally wrong? And I have a hypothesis about that, which is that, well, it's basically because it serves lawyers' interests. Okay, so the American Bar Association has a document called its Model Rules of Professional Conduct, which basically explains their views about legal ethics. And so the ABA's Model Rules of Professional Conduct say that it's wrong to violate attorney-client confidentiality, even to prevent heinous criminals from going free. Right, so even if you know that your client is guilty of some terrible crime, because maybe he confessed to you, you should not give that information to anyone else where it might cause harm to your defendant, to your client. However, the same document also says that it is okay to violate confidentiality if doing so is somehow necessary to collect your fee. Right, so let's say that you have information that your client gave to you in confidence, which indicates that the client actually has money hidden somewhere. And he's hiding this money to escape from paying alimony. Okay, you cannot reveal that in order to enable your client to be forced to pay the alimony, but you can reveal that information in order to force the client to pay you your fee. Okay, so now it seems really weird that the importance of confidentiality is so high that it enables you to keep secrets that let heinous criminals go free, but you can also violate it in order to get paid. And really the only explanation that I can think of here is that the ABA has designed its conception of ethics for the interests of lawyers, which would not be that surprising because the ABA is a professional association of lawyers. Of course, they're going to want to make the rules of what they consider ethical for their own interests. Right, so in conclusion, promoting injustice is morally wrong, and it doesn't become morally acceptable merely because it's your job.